of North Cotabato et al. V. Government. Facts: on August 5, 2008, the government of the Republic of the Philippines and the MILF, through the chairpersons of their respective peace negotiating panels, were scheduled to sign a Memorandum of Agreement on the ancestral domain aspect of the GRP-MILF Tripoli Agreement on Peace of 2001 in Kuala Lumpur, Malaysia. The MILF is a rebel group which was established in March 1984 when, under the leadership of the late Salamat Hashim, it splintered from the Moro National Liberation Front, then headed by Nur Mizuri, on the ground, among others, of what Salamat perceived to be the manipulation of the MNLF away from an Islamic basis towards Marxist-Maoist orientations. The signing of the MOAD between the GRP and the MILF was not to materialize, however, for upon motion of petitioners, specifically those who filed their cases before the scheduled signing of the MOAD, this court issued a temporary restraining order enjoining the GRP from signing the same. The MOAD was preceded by a long process of negotiation and the concluding of several prior agreements between the two parties beginning in 1996, when the GRP-MILF peace negotiations began. On July 18, 1997, the GRP and MILF peace panels signed the Agreement on General Cessation of Hostilities. The following year, they signed the General Framework of Agreement of Intent on August 27, 1998. The Solicitor General, who represents respondents, summarizes the MOAD by stating that the same contained, among others, the commitment of the parties to pursue peace negotiations, protect and respect human rights, negotiate with sincerity in the resolution and pacific settlement of the conflict, and refrain from the use of threat or force to attain undue advantage while the peace negotiations on the substantive agenda are ongoing. Early on, however, it was evident that there was not going to be any smooth sailing in the GRP-MILF peace process. Towards the end of 1999 up to early 2000, the MILF attacked a number of municipalities in central Mindanao and, in March 2000, it took control of the town hall of Causwagan, Lanao del Norte. In response, then President Joseph Estrada declared and carried out an all-out war against the MILF. When President Gloria Macapagal Arroyo assumed office, the military offensive against the MILF was suspended and the government sought a resumption of the peace talks. The MILF, according to a leading MILF member, initially responded with deep reservation. But when President Arroyo asked the government of Malaysia through Prime Minister Mahathir Mohamad to help convince the MILF to return to the negotiating table, the MILF convened its Central Committee to seriously discuss the matter and, eventually, decided to meet with the GRP. The parties met in Kuala Lumpur on March 24, 2001, with the talks being facilitated by the Malaysian government. The parties signing on the same date the agreement on the general framework for the resumption of peace talks between the GRP and the MILF. The MILF thereafter suspended all its military actions. Formal peace talks between the parties were held in Tripoli, Libya from June 20 to 22, 2001. The outcome of which was the GRP-MILF Tripoli Agreement on Peace containing the basic principles and agenda on the following aspects of the negotiation: security aspect, rehabilitation aspect, and ancestral domain aspect. With regard to the ancestral domain aspect, the parties in Tripoli Agreement 2001 simply agreed that the same be discussed further by the parties in their next meeting. A second round of peace talks was held in Cyberjaya, Malaysia on August 5 to 7, 2001, which ended with the signing of the implementing guidelines on the security aspect of the Tripoli Agreement 2001, leading to a ceasefire status between the parties. This was followed by the implementing guidelines on the humanitarian rehabilitation and development aspects of the Tripoli Agreement 2001, which was signed on May 7, 2002 at Putrajaya, Malaysia. Nonetheless, there were many incidents of violence between government forces and the MILF from 2002 to 2003. Meanwhile, then MILF chairman Salamat Hashim passed away on July 13, 2003, and he was replaced by Alhaj Murad, who was then the chief peace negotiator of the MILF. Murad's position as chief peace negotiator was taken over by Mohaghar Iqbal. In 2005, several exploratory talks were held between the parties in Kuala Lumpur, eventually leading to the crafting of the draft MOAD in its final form, which, as mentioned, was set to be signed last August 5, 2008. Held the Memorandum of Agreement on the Ancestral Domain aspect of the GRP-MILF Tripoli Agreement on Peace of 2001 is declared contrary to law and the Constitution. Ratio: the petitions are ripe for adjudication. The failure of respondents to consult the local government units or communities affected constitutes a departure by respondents from their mandate under EO No. 3. Moreover, respondents exceeded their authority by the mere act of guaranteeing amendments to the Constitution. Any alleged violation of the Constitution by any branch of government is a proper matter for judicial review. As the petitions involve constitutional issues which are of paramount public interest or of transcendental importance, the court grants the petitioners in intervention and intervening respondents the requisite locus standi in keeping with the liberal stance adopted in David v. Macapagal-Arroyo. Contrary to the assertion of respondents that the non-signing of the MOAD and the eventual dissolution of the GRP peace panel moot the present petitions, the court finds that the present petitions provide an exception to the moot and academic principle in view of the grave violation of the Constitution involved, the exceptional character of the situation and paramount public interest, the need to formulate controlling principles to guide the bench, the bar, and the public, and the fact that the case is capable of repetition yet evading review. The MOAD is a significant part of a series of agreements necessary to carry out the GRP-MILF Tripoli Agreement on Peace signed by the government and the MILF back in June 2001. Hence, the present MOAD can be renegotiated or another one drawn up that could contain similar or significantly dissimilar provisions compared to the original. The court, however, finds that the prayers for mandamus have been rendered moot in view of the respondents' action in providing the court and the petitioners with the official copy of the final draft of the MOAD and its annexes. The people's right to information on matters of public concern under Seconds 7. Article 3 of the Constitution is in splendid symmetry with the state policy of full public disclosure of all its transactions involving public interest under Sector 28, Article 2 of the Constitution. The right to information guarantees the right of the people to demand information, while Section 28 recognizes the duty of officialdom to give information even if nobody demands. The complete and effective exercise of the right to information necessitates that its complementary provision on public disclosure derive the same self-executory nature, subject only to reasonable safeguards or limitations as may be provided by law. The contents of the MOAD is a matter of paramount public concern involving public interest in the highest order. In declaring that the right to information contemplates steps and negotiations leading to the consummation of the contract, jurisprudence finds no distinction as to the executory nature or commercial character of the agreement. An essential element of these twin freedoms is to keep a continuing dialogue or process of communication between the government and the people. Corollary to these twin rights is the design for feedback mechanisms. The right to public consultation was envisioned to be a species of these public rights. At least three pertinent laws animate these constitutional imperatives and justify the exercise of the people's right to be consulted on relevant matters relating to the peace agenda. 1. EO No. 3 itself is replete with mechanics for continuing consultations on both national and local levels and for a principal forum for consensus building. In fact, it is the duty of the presidential advisor on the peace process to conduct regular dialogues to seek relevant information, comments, advice, and recommendations from peace partners and concerned sectors of society. 2. Republic Act No. 7160 or the Local Government Code of 1991 requires all national offices to conduct consultations before any project or program critical to the environment and human ecology, including those that may call for the eviction of a particular group of people residing in such locality, is implemented therein. The MOAD is one peculiar program that unequivocally and unilaterally vests ownership of a vast territory to the Bangsamoro people, which could pervasively and drastically result to the diaspora or displacement of a great number of inhabitants from their total environment. 3. Republic Act No. 8371 or the Indigenous Peoples' Rights Act of 1997 provides for clear-cut procedure for the recognition and delineation of ancestral domain, which entails, among other things, the observance of the free and prior informed consent of the indigenous cultural communities/indigenous peoples. Notably, the statute does not grant the executive department or any government agency the power to delineate and recognize an ancestral domain claim by mere agreement or compromise. The invocation of the doctrine of executive privilege as a defense to the general right to information or the specific right to consultation is untenable. The various explicit legal respondents effectively waived such defense after it unconditionally disclosed the official copies of the final draft of the MOAD, for judicial compliance and public scrutiny. In sum, the presidential advisor on the peace process committed grave abuse of discretion when he failed to carry out the pertinent consultation process, as mandated by EO. Number 3, Republic Act No. 7160, and Republic Act No. 8371. The furtive process by which the MOAD was designed and crafted runs contrary to and in excess of the legal authority, and amounts to a whimsical, capricious, oppressive, arbitrary, and despotic exercise thereof. It illustrates a gross evasion of positive duty and a virtual refusal to perform the duty enjoined. The MOAD cannot be reconciled with the present constitution and laws. Not only its specific provisions but the very concept underlying them, namely, the associative relationship envisioned between the GRP and the BJE, are unconstitutional. For the concept presupposes that the associated entity is a state and implies that the same is on its way to independence. While there is a clause in the MOAD stating that the provisions thereof inconsistent with the present legal framework will not be effective until that framework is amended, the same does not cure its defect. The inclusion of provisions in the MOAD establishing an associative relationship between the BJE and the central government is, itself, a violation of the Memorandum of Instructions from the President dated March 1, 2001. Addressed to the Government Peace Panel. Moreover, as the clause is worded, it virtually guarantees that the necessary amendments to the Constitution and the laws will eventually be put in place. Neither the GRP Peace Panel nor the President herself is authorized to make such a guarantee. Upholding such an act would amount to authorizing a usurpation of the constituent powers vested only in Congress, a constitutional convention, or the people themselves through the process of initiative. For the only way that the executive can ensure the outcome of the amendment process is through an undue influence or interference with that process. While the MOAD would not amount to an international agreement or unilateral declaration binding on the Philippines under international law, Respondents' act of guaranteeing amendments is, by itself, already a constitutional violation that renders the MOAD fatally defective.